Hey, good people. Hello, 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 hello. How's everybody doing this evening? I know it's pretty late, but I didn't want to miss out by not bringing you guys the content from today. Man, when I tell you it was some fireworks at the court today, Mr. Steele was not having it. Mr. Steele was not having it, guys. He was going in on them. Okay, here's what happened. Hold on, let me turn this thing down because folks texting here. All right. Um the judge had ruled, well, he said that he gave the prosecutor a deadline for them to submit the witness list at complete witness list along with an index, right? So they were supposed to have it today by 9 o'clock. They're supposed to meet, and then by 12 o'clock, the judge is supposed to come in and they're supposed to handle whatever they need to handle, right? So it turns out that the list was not complete, right? And the judge was given the prosecutors until Monday. And then it moved over to Wednesday of next week. It was crazy, guys. It was so crazy. And I'm going to go ahead and play. And I'm telling you, the judge, I'm kind of disappointed in Judge Granville on that one. I'm very disappointed because I thought he was going to stick with his word of, holding them to be responsible, right? But they were not responsible. So, therefore, hold on a second. Therefore, I'm very disappointed. But I'm gonna go ahead and play this for you guys because it's pretty sad. It's pretty sad, I think. Hold on a second. Let me just go back to recordings. And you know me, I had to do it the getaway because they did not have the camera guy again. So if you hear that scratchy noise, if you hear people in the background, please excuse it. I did the best I could. Okay, guys, I did the best I could. But here it is from earlier. Okay. Hold on.
Okay, fine.
John, of the
You hand that to me, so.
Hold on.
report required us to index the witness list. I'm sorry, and so we put next to each witness the acts that we anticipated using them for. We provided where we had phone numbers. We provided the phone numbers, the addresses, their dates of birth. There are a few at this point left that don't have an act, or a few that don't have phone numbers.
What do you call a few?
On the lay witness list, Your Honor, we have out of the
Okay.
What we had. This is the initial version that we provided.
You want to just read? I was going to ask you, do you want to repopulate it? And you need a motion?
Yes, that's what we got.
That's fine. That's fine. I'll let you finish your thoughts on that as well.
Yes, Your Honor. I have one.
we're here for
Okay, all right.
John, of the,
Can you hand that to Ms. Weaver, please?
I apologize. Okay, of the, lay witnesses that are listed,
Lay witnesses go from what number to what number? 1 to
211,
11?
yes, 16 at this point, 17.
Hold on, 1 second.
Sad that he's keep giving them chances after chances after chances. I'm really
The
disappointed.
lay witnesses are 1 to 211?
That's
Is that what you're saying?
212, yes.
Okay.
17 of the named people have no phone number, Your Honor. 3 of those people are deceased.
You mark those, yeah, I see you mark the deceased people in red.
Yes,
Okay.
and there are incarcerated 1, 2.
Are those marked accordingly?
They are, the address is listed as the place where they are incarcerated. For instance, witness number 201 is, witness number 200 is listed as being in Macon State Prison. Witness,
You said 200?
I'm sorry, I'm looking at the repopulated list. Yes, Your Honor.
Is it been read? Now, am I looking, I'm sorry, the extreme left column or the inside, like left column to the left side of the paper to the second column over? Says,
So, Your Honor, if I could, what you have in front of you is the initial list that was provided. At around 11 o'clock, Mr. Weinstein, 11:15, Mr. Weinstein sent us an email with, after they reviewed, they had an opportunity to review the witnesses. At 11:15, Mr. Weinstein sent an email on behalf of all of the defendants about what information was not in the document.
in terms of lay witnesses
Both lay and professional.
and profession,
Yeah.
what was missing?
What was missing.
Okay.
At that point, we went back into the document, which is what we've been working on since, until the court came in,
Okay.
to repopulate, because that has not been distributed yet or printed yet, because we have been working to respond to his email. But we can tell you, based upon what we have now, what is different from the list that you have. Now, we can wait until we reprint it and give it to everyone so they can see it, but we have been endeavoring to meet what they said that they were going to activate is use the document. And that's what we've been repopulating.
I understand. When, and just from, I'm looking at the professional witness list, which goes from 1 through 476, is that right? Or thereabouts? I'm looking at, and for example, from .410 through the end of 476, there's nothing that those go to, or accurate other incidents that they go to. Are you still in the process of updating those?
Correct, we have populated at this point, we only have 25, maybe 26, I'm gonna count again, professional witnesses that we have not associated with. So from.
So you're missing 25 professional,
That we do not have to associate with.
okay, and then the lay witnesses,
And for the lay witnesses, part of associated
I
acts,
think you have,
we were missing just solely from 202 to 211.
Yes.
So we have filled in some of those as well.
okay. All right, when do you think you'll be finished with populating the whole list as you all see it, taking into account the people that are, that do not have phones, that you can't otherwise provide for, but you have other identifying data? When do you think we'll be able to have those done by?
We can endeavor, we have to look for the acts, because that's how they are.
Well, I I'm just asking you, when do you believe, I mean, this is a good effort and a good start. I'm just wanting to know, when would the rest of this be tendered? Could we get it done by Monday?
Yeah, we would ask that the court allow that. And Your Honor, additionally, Ms.
I'm talking, when I mentioned Monday, I'm talking about this for purposes of completeness. I'm looking at this coming Monday, the 29th.
Yes, Your Honor, that was our understanding.
I'm sorry, the 25th.
And we have as well been provided 2 storage devices from members of the defense team to add to those devices some information that we have come into recently, phone dumps that we got from 2 of their clients in the recent months. One for one client, one for another. In the last, we got that yesterday from the Sheriff's Department. And any additional information, we are, and they have been availing themselves of our availability here to let us know what they believe they've been missing and things of that nature. But
okay, I also, and this is very fine an effort. Is there an index that is also forthcoming in regards to what discovery has been provided?
So, Your Honor, yes, that was what I spoke with them about. The first, the witness list with the acts and the counts that they're associated with was our first indexing of the information. But what I wanted to do and what I told them I was doing was to aggregate the discovery and then organize it in a manner that is searchable by acts and by defendant.
Okay.
That has, there are, as we've heard previously from counsel for the defendants, that there are approximately 4.5 terabytes of data. And that process of putting that data onto one single source and then sorting it is something that we have now sought the assistance of our IT department, and they are assisting us. I have begun that process. It has caused a few challenges, but that is something that I think we can overcome by Monday.
So you could give me an update on the indexing on Monday as well?
Yes, Your Honor.
Okay. All right. Is your plan to update what you have at this point in time or send it out electronically to Mr. Weinstein and his colleagues? What is your thought on that?
Your Honor, I will communicate with my colleagues across the aisle, and if they would like to give me a device, I have myself purchased in order to put this on here 2 pricey devices. I don't mind giving them those devices in exchange for empty devices like these. I think that providing to us a means to aggregate and then organize and give to them on a solid drive is probably, and something they can search without having to download it, perhaps the most optimal method of delivering it.
Okay.
And we are also going to just email the list that we have today and then provide them that as well.
You do need to update some of it, and I think that would be helpful for you to go through with your colleagues, at least to kind of to let them know, which people you don't have phone numbers for, so that don't even look, and also just I know you, like, for example, you put in red the people who are deceased, so they already know not to continue to deal with them. I think you have a certain population that is in custody. Those might also need to be probably probably updated as well in another color or whatever else. And then the ones that are blank that you're still endeavoring to get, and I can take stock on that on Monday. Mr. Weinstein, does that work for you in terms of electronic format? I didn't ask you to start walking, I asked you a question. Yes, sir, okay. Since you have taken over from Mr. Jimenez, Mr. Chada Jimenez, okay, all right, so as the chief technology officer.
I endorse not to.
Too late now.
I want to make sure I understand what we're going to be getting from the state. Are you going to say 5 terabyte hard drive, is that what you're saying? It has the discovery restored by acting count? I just want to make sure I understand.
Sure.
Your Honor, as I've explained to the court, what I have purchased is a 4 terabyte drive and a 2 terabyte drive. I endeavor to get the fastest transferable, largest storage devices that I could obtain. And that's what was at the store. So I am asking that we have a 16 terabyte drive. It is substantially slower when we begin to upload the data. The transfer rate said several days. So the ones that I have now obtained take substantially less time, but still they take time. So I am simply asking that if either counsel for either defendant would just provide to me 5 terabytes of storage, I can give it back to them. If they want to give it to me in the format of a WD drive, it will just take a little bit longer, but
How long are we talking about? I mean,
I think it will take about, on the faster drives, it will take about 3 days to,
3 days?
yes, it
Any
is.
way can you transfer it any faster than that?
Well, you're not.
We can do it. Yeah, I think that the method of transferring it electronically is not something that they are amenable to, given the concerns regarding Dropbox.
Well, I know that, but let me just make it part of it.
I think Mr. Steele is coming up now. Wait till you hear Mr. Steele, y'all. Thais, man, it was horrible. Just keep listening. Keep listening. Taisha, it was horrible. I think Mr. Steele is coming up because it looks like they're getting more time, right? Wait till you hear Mr. Steele. And I want to hear y'all opinion.
I'm going to go ahead and have our court's IT person kind of come. I want to figure out a solution for you. What's the fastest way to do it? So let me see if I can weigh in on that particular issue.
No, I still don't know what we're receiving. And these 4 plus 2 terabytes. Are we receiving only discovery we had previously received, but now it's organized in a fashion under everything? Or is this new discovery that we have not received?
We are getting over the discovery that has been previously given to the defendant and any supplemental discovery. Right now we have opened up.
And I understand there have been 12 discovery iterations. Is that correct or thereabouts?
Yes.
Okay. So is this additional information in addition to the 12
Yes.
they already have? So is it your
Absolutely, y'all. Yep, VK, too much.
reformatted drive to
Wait till y'all hear
several
Steele.
which you've
Mr.
already
Steele's
given
gonna
and
come up.
these next
Wait,
two,
y'all. Wait.
dumps.
Yes, opened up and jail calls.
That hurt.
Members of the are filling out the jail calls, the name, as well as the free call. But yes, additional jail call, court be format, we can provide them with now, but, we are attempting to sort it.
Okay, when can you finish sorting it and making searchable? When will you be finished with that?
We can provide by that 10 o'clock. But we can provide have all of that downloaded and stored on external.
Okay, I think that the council have expressed their concern about Dropbox is not secure. It's not even secure.
Okay, so,
So Lord's advice that's
Wait till
capable.
Mr. Steele
Okay,
comes
so
up, y'all.
I'm
Wait.
I've asked either Aaron or Deja one from.
Wait till Mr. Steele come up. You're gonna hear it.
I just want to ask some general questions about what would be the best way to, and fastest way to transfer this particular information, so.
Yep, you're giving more time. More time, Tasia. Wait till you hear Mr. Steele. He's not playing with them.
And then will we have an index for the witnesses of which witnesses are associated with which aspect of this?
Yeah, I think the witness list Mr. Weinstein has, to the extent that it's been built, the acts that are next to it.
That witness list that we received this morning, which was supposed to be completed every way, we spent 6 or 8 of us this morning, 2.5 hours of time going through that list, cell by cell, element by element, trying to find out these reasons. And as you know, it was tremendously.
Thanks, Taisha.
Going through that exercise again. I mean, my understanding was.
Okay, well, back up a second. Back up. What do you mean by the first thing you said about it being incomplete in terms of because it's got the act it goes to on the witness. Because I can't recall. Let me get your exact phrase all of this line. What was it for thing? Oh, okay.
I can give you specifics, Your Honor. And there were 77 witnesses, combining lay and professional, where no counts were identified.
Okay, I want to say that the state has endeavored to complete most of those. I'm taking a look at the lay witness list right now.
Yeah.
And I marked it as court 1. And it looks like, for the most part, like for example, from 1, or they've got 2, which really is when it starts, 2 through 201 seem to have the act listed. 202 through 211 do not. That's what I have today.
That's correct. That's correct.
Okay, on the professional list, we have some holes. That, like, for example, you've got 9, but you do have the act it goes to. And you've got, for example, 5 that's missing a phone number.
Special witness, Your Honor, there were 94 witnesses that had no contact information whatsoever. No email, no phone.
Like for example, number 50, Dean Williams from APD.
There's an example we have.
Yeah, man, there's no phone number, no email.
No email. So, yeah, and that's not a typical. In that there are professional lists there are 161 witnesses, several of us under that, make sure that's okay. But even if there are 161, I think also right. So when I say that what we have to do is go through all of this and see how many of the key phone numbers, or, you know, they didn't have a phone number, they also didn't have an email. There was quite a few of those.
Yeah, I see what you're talking about. There are,
But it was a very long exercise to do something that honestly we're not expecting to do. Based on your honor's directive, we were expecting these lists to be complete. And here we are, like, almost 10 months into this, and we're still going to the same thing. Well, next time, maybe.
well, I think it's gone from with the list you have to something that's probably a little bit better. Now, I'm not commenting on why, but, you know, looking at the case law, it looks like my remedy, I mean, Mr. Weinstein, I understand, and you know, Mr. Steele, and all the other defense counsels are saying to the court. News tells me, though, the remedy is to more than likely, the first thing the federal court's asked me to do is to continuously look at it. I do have the authority if I find, you know, if I find prejudice and I find mistakes intentionally done this, I can exclude it. But I'm trying for this court, I don't want to be slowed down in terms of witness presentation. I want you to have everything. So I appreciate you bringing it to my attention. I think that this is much better than what you had before, to the extent. But I'm like I said, I share your concern, but I'm gonna go ahead and probably have it updated a few more times before I'm.
No, I agree that with the court that each iteration seems to be improved from iteration before. You know, it's what you saw on this last Friday, and the statement came coming around 60. We disagree. I think there's over time. But Your Honor, you said it is 10 is doing. And between last Friday, between then and this morning, they added another 37 witnesses. Another 37 witnesses. Now, they're going to do a new witness list, they're giving us new witness list on Monday. How many more witnesses are going to be on that? Another 37, 40, 50, 100? It's only getting worse. It's snowballing. Yes, the quality of the witness list is improving. But these late disclosures of witnesses continue to
Late would be we're in trial. And we're in trial and the witnesses.
We are in trial.
And a witness has been called and I gotta take a pause. That's what late is.
No, late is now.
So, I'm trying to kind of get where we are.
But what you understand how this presses us when we're trying to prepare for trial and we're getting all of these new witnesses come on us 9 weeks after the start.
Yeah, it was. I heard Mr. Geary say they're ready to go. This is, you know, I'm kind of very shocked about that, but
Can I have this stuff? I might not feel out. I just wanted to discuss state property.
okay.
Thank you.
Okay. Can we make this kind of short? So we have juries. Okay, all right, so.
Here comes Steele, y'all. Here comes Steele. Here comes Steele.
And there's also case files for some other acts back and forth, other times.
Steele is coming up. This is Weinstein talking right now.
I didn't do everything, but I don't want to have to go through everything and go to find. So if we can just keep the new stuff separate, and I think they'll make a lot easier.
Can you get it both ways?
That would be.
Do you want to have you get it both ways? That's fine. I'll order it to be done both ways, okay?
Here comes Steele.
What else you got?
Here goes Steele.
Mr. Steele, anything, sir? Anything else?
I gotta hide on this one.
I'll include court 1 and court 2. Actually, I'll include these as next court 2 exhibits more than this one. For your, in regards to, this emergency motion.
I have to put Mr. Steele picture up so y'all can see him. Here we go, y'all. He gonna get him. He gonna tear him a new one, y'all.
I don't share what.
I know that, Mr. Steele, but it's my interpretation, okay? And I believe that Justice Boggs wrote very clearly about what this court's options are. And I'm not to the point where you want me to be at this point. I'm getting close, but I'm not. But you've argued that eloquently yesterday. So what else do you want to tell me in regards to that?
Division 7.
And in Division 7, 2023 case, that issue was waived. News did not raise that objection for 2 days later after the evidence was introduced, so they went on the plain error. I understand it. I do understand it.
I'm cutting him off, y'all. Wait till Steele coming.
And I have never been on court, but here are the real facts. And if you're not outraged, then I have totally missed the point. The prosecution presented this case to the grand jury and got an indictment on May 9th, 2022. Mr. Williams has been in custody along with everyone else since that date. The prosecution has met me every time, 4 times, on bond, saying that there's not one condition that can be fashioned by this honorable court to permit Mr. Williams to have the statutory right to bond. I immediately filed a demand for a speedy trial on the indictment. I requested and demanded respectfully discovery, and the prosecution announced what you just said. It was Don Geary, quote, "We're ready to go," end quote, had all the discovery indexed to make it easy to understand what count, and if it was in the RICO count, which is count 1, what overt act pertained to that discovery. All witnesses had valid, current information as mandated by statute, and it was told to us that the discovery was so large that I needed to bring an 8 terabyte drive as well as everyone else to the prosecutor on a date certain. All discovery would immediately provide an index and cross-reference from witness to where in discovery and which count for overt act was count 1. I memorialized those conversations that the Honorable, greatly accomplished Court Reporter Weaver has memorialized. I'm confident as well. I memorialized in the letters on June 8th of 2022 and June 16th of 2022, which I attached to my emergency motion that I filed on September 8th of 2023, which is in the record, and I asked this Honorable Court to adopt it as an exhibit. I had a coworker, the Honorable Griffin Lail, L-A-I-L, come down to Mr. Geary's office as he directed with that 8 terabyte hard drive. Don Geary did not even have the courtesy, and I'm not hurting him, I don't know what he was doing, but to come meet with Griffin Lail, but he was told that the state of Georgia, through the district attorney's office of Fulton County, has unilaterally, in violation of what it told me, and against what it told this honorable court and everyone else, that they decided that discovery would be served in a different way. Discovery, Your Honor, was now set in 12 pieces. There's now a 13th piece coming that I just heard about this moment. The most recent piece came at the end of July of 2023. That is not, I agree with Mr. Weinstein, this discovery is late. The statute mandates 10 days before trial, which you told me and everyone else upon the urging of the prosecution that trial started January 4th of 2023 or before. It did? Well, then they're late. They are 14 months after they promised me all of the discovery was coming in perfect form. Your Honor, then the witness list. The witness list comes out on December 1 of 2022. I met it with a motion. I filed a motion. I continue to ask to this day, this is not a complete witness list. I want to find these witnesses. Please help me. I got nothing. I get a witness list on January 23rd, 2023. It's again not in compliance with the law, and no one cares. Even though it's told to your court over and over again, we have everything under control. It's no problem. The state had the nerve to ask for a continuance because I needed more time. That's what they wrote.
This initially, but I said we need to go.
And I objected to the continuance because I want to go.
Yeah, I understand.
And the state said, no, but we'll give you everything. We want to make sure that you have effective assistance of counsel and a right to understand the case. That was a misrepresentation. They had no intention of giving over a witness list. There is no witness list, Your Honor. It's a misrepresentation in February 2023. I've never been to court. I'd be outraged. That was said to you by District Attorney Love. There is nothing in February 2023. You asked Ms. Love, is what Brian Steele is saying is true? That you had 266 witnesses on September 8th, 2015, and Ms. Love said, no, I am wrong. I am not wrong. The state then calls a witness list March 13, 2023. Your Honor, there are names. There are names. I complained. I said, that's not a witness list. Those are names. The state doesn't care. They don't do anything about it. That is a misrepresentation to the court. That you're not outraged yet? 266 people are hoisted upon me and everyone else on the defense side on September 2023, in addition to the half terabyte of information that came out at the end of July. Now I'm hearing for the first time about 2 phone dumps. I don't know if they're, whose phones they are. No one ever spoke with me. I never heard about that. Now additional reports? No, I'm not accepting it. I'm objecting to it. I don't want this court to accept it. I'm asking you to be the court that you are. To be fair that you are to everyone. This is not a fair playing field. This is wrong. And you have been told over and over and over again, misrepresentation. This goes back to June of 2022. 22! We are now 14 months later, 15 months later. If I was in your room, I'd be out of my room, off the bench, and screaming at someone.
So I'm not going to do that because that's not professional. Keep it to. I understand this too. You're very annoyed with the case and what you've been told in regards to stuff.
I have been misled. The court been misled. I have respect for this court. I have the ultra respect for this court. You are the definition of what a judge is. You've got to step in. I am begging you to step in. This is wrong. People are watching this case. It shouldn't matter, but people are watching this case. This shows badness on us. We are a great bar here in Fulton County and the state of Georgia. We are great lawyers. The district attorney's office of Fulton County is great. I've defended members of the Fulton County District Attorney's Office. This is unacceptable. Ms. Love's constant and continuous misrepresentation cannot be tolerated. And her interruptions of this honorable court, I will not sit there anymore. I will object to interrupting the court every time she does. Every time you rule against the state, Ms. Love stands up and interrupts you and continues. That will never go on anymore because I have respect for you and what we're doing here. There are no consequences. Do you realize what you're doing is rewarding this conduct? By saying, hey, this is pretty good, we're getting there, give it to me by Monday. We should have had this in December of 2022. You are not creating any type of fair trial for anyone here. You are doing the opposite. You cannot let this go on. This bad faith is so bad, Your Honor. The prejudice is so deep. Not only was everything ready to go in June of 2022 for the DA's office, 266 people were hoisted on us on September 8th of 2023. Do you know what this witness list today did, Your Honor? Today, we have an additional, and if you ask Mr. Partridge, he's going to tell you 37 people, if you ask Mr. Williams, he's gonna tell you it's 43. I have 42. Mr. Weinstein and I, Mr. Harvey, and Ms. Westmoreland have 42. But regardless, 37 to 43 additional witnesses. Your Honor, that is since September 8th of 2023, 12 days later. Do you realize I'm responsible for an additional 308 witnesses? Now you're giving me more discovery in addition to a half a terabyte of discovery. I don't know if the court realized a half a terabyte. I know what that. 3 million PDFs. 3 million PDFs. You know, I'm reviewing it. Now I get 2 more phone calls. I'm not taking it, Your Honor. You make me take it, I'll take it from you. I'm not taking it from the state of Georgia. This is wrong. How about the do not serve in discovery, Your Honor? How insulting is that you presented up last time? And I stand with it now. And there's no excuse. If I did that, you know, Judge, I could be disbarred. I could be disbarred. You know the canons of ethics, because you always were candor with the court, professionalism, do not serve discovery that was due in December 2022. I've never seen any of this before. I've never spoken like this before in a court. This pains me. I go home and I sit there and I pray and I say, how is this possible? I consider this love a friend. I never expected this. You have to step in. Mr. Williams.
So what do you ask me to do?
I have the following remedy. All 308 witnesses are disqualified from testifying in this trial. They cannot be mentioned, and I don't know if they benefit or hurt, but they cannot be mentioned by the state. If they're exculpatory, we will find them and we will call them. The state has Brady and Giglio exculpatory obligations that must be continued. Mr. Williams,
Is this since September the 8th of 2023?
yes, 308 people. Mr. Williams must be granted bond today. I don't have enough time to go and meet with him after court on the jail calls, privilege calls, and at the jail and do that. I need access to him 24 hours a day, 7 days a week, in court and out of court, because he has to help me. And I have a responsibility to him to advise him of what's going on in the case. I don't have the ability to do it with 308 people and all of this half a terabyte of information. He can be in whatever confine you want. I think he can have just a signature bond and go around. I don't find him to be anything of Baron Ayala, but if you do, lock him in a home, give him a cell phone that doesn't have internet. We will talk on a regular flip phone. I need access to him. I can't do it now. I am released. When I say I'm talking about every single person here, unless they don't want me. I am released, as well as everyone here, from following any mandates of 1716.3, 1716.6, and 1716.8, because the state has violated all these code sections. And the court has the power to do what it deems proper in the interest of justice. So I'm not giving, I already gave a robust witness. I'm not giving another witness listen if you ordered me to do it, and I'm not giving any documentation whatsoever that I'm going to use in my case in chief. The reason for that is I am now a slave to the prosecution jerking me around on a tether because I'm just running around on their case rather than doing what I want to do and get together with all of my information. I'm not doing it unless you order me to do it. I am going to order the remedy, not 3 days, not the Friday before trial like I asked, not the Friday before every week. I want 2 weeks notice of who witnesses are coming the following or whatever. When we start trial, 2 weeks before that, every single witness, and I want that witness to be robust because I know it's going to happen. Oh, we had a witness who couldn't come, so we supplemented this witness, and sorry about that. I want 2 weeks preparation time and that the state has to give more than the witnesses, so I'm not surprised and I don't waste my time or the court's time or the jury's time. I want the real names of who's coming. It was told to you that 3 months or more of trial. That's like saying, John, Bruce Harden has been married 3 months or more. He's been married 50 years to this woman who's fortunate enough to marry him. It's ridiculous to say 3 months or more. You ask the question, how long will it take? It's not 3 months or more, it's 687 witnesses. So I want a true witness list who they're calling. Also run the GCICs for me. I have to pay for every GCIC and it takes weeks to get them back. I want every single witness and it is not illegal under OCGA section 35-3-30. Division 3 defines criminal justice agency, which includes the prosecution. And the third OCGA section 35-3-34A, as in Elisa. 2, make criminal history records of the defendant or witnesses in a criminal action available to counsel for the defendant upon written request from the defendant's counsel. I am making this request, and it's on the record, it's in writing, if you need it in writing. I am no longer, I have done it all, Judge. I have waited, Your Honor. I've waited the entire year. Every time I'm getting piecemeal discovery, I review it, and it changes what witnesses are being impacted. It changes strategy. It changes how I'm going to need witnesses. Everything changes. It's ended. Honor, it has to end. And how in the world am I getting new jail calls now, new reports now, and the court is saying, what's the fastest way to get it to? I'm not taking it. I'm not accepting it without you telling me I'm accepting it. I'm not taking it for the prosecution anymore. Your Honor, I want a real index to discovery. You said Wednesday at 9 a.m., a real index to discovery. And you talked about your history. And you know what you need to prove each count and what count it belongs to. And you ordered the prosecution to do. We don't have that. We have a witness list and then a overt act or a count next to it. That is not in the discovery. That does not index the discovery. Your order was again violated. Words mean something. Lawyers' words mean everything. Without your word, you have nothing. Nothing in this case. I am asking your honorable court to do exactly what I said. I ask your court to please set the bond for, it could be everybody here, but Mr. Williams, I'll take whatever condition. I can't do this. I cannot do this case because of misconduct by the Fulton County DA's office. Over and over and over. And they had all this in June of 2023. I can't stop that.
You said June 2022?
Yes, I apologize. Thank you. That is 15 months ago they could have provided all this. Don Geary didn't lie to the court. He didn't make me buy an 8 terabyte drive and have a law clerk go to his office. They changed the gamemanship. That cannot happen. That will not happen in this honorable court on the bench. I'll answer any of your questions.
All right. Ms. Love would say, why shouldn't I grant an extreme remedy?
For 2 reasons.
I mean, because it looks like, from looking at Weaver's latest pronouncement of it, is prejudicing the defendant in bad faith by the state.
Yeah.
And his argument basically is the witness list keeps growing exponentially, and they need to be able to prepare. So to that extent, I mean, you have added on conservative as anywhere from 266 to 308 witnesses. And that's as of September the 8th of 2022. So why shouldn't I exclude those witnesses?
Your Honor, thank you for giving me the opportunity to respond. And the first thing that I would like to ask
Listen to this. Listen to this.
is that the court takes stock of and prohibit the deeply offensive misrepresentations, blatantly false, and intentional disrespectful misrepresentations that Mr. Steele continues to make, simply to color the court and apparently to color the general purpose, the general public, towards his means, his ends. And Your Honor, it is one thing to state that he is disadvantaged. It is another to continue to sit and disparage a member of the bar whom he claims is a colleague, an esteemed colleague, in such a blatantly false and disrespectful manner. I would ask that the court require that Mr. Steele conduct himself in a manner befitting a member of the bar and stop disparaging colleagues across the aisle. That said, Your Honor, there is nothing in the, what we have done is attempt to comply with what the court has ordered and what the defendants have requested. There is no information that has been provided to the defendants in this witness list that we have provided today that is not in the discovery that we have provided to them. The defendants have asked for specific reports from 2015, which have already been given to them in the first round of discovery, which contained all references and incident reports that we have included witnesses for on this list. These names are not new in any way. I understand that language is used in order to persuade the court that the state is doing something that is improper, but I can assure the court, we can show the court where it is that these names have been represented in prior discovery given to the defendants in the discovery. And Your Honor, we categorically disagree with what Mr. Steele has represented in order to affect. Understandably, he is representing his client, but in order to affect those means, he has stooped to levels I am very surprised about, Your Honor. What we have provided to the defendant does not rise to the level of 200 and any odd names that are new.
Well, why are they telling me 266 then? Did they pull it out of the air or what? I mean that it seems like that from looking at defense 1 through 4, that the court took stock of last week. There's been differences and additions to the witness list.
I guess, Your Honor, for the reason they insisted that Mr. Brown wasn't here at the time.
Let's focus.
Yes, Your Honor, Your Honor, I don't know why the representation needs to be this high number. Again, there is not a witness that.
Okay, well, let me just kind of place you imagine yourself on the other side, okay? You are trying to prepare for trial. You've been led by your colleagues we're ready to go, ready to give you everything. And this was June of last year. And instead of being given like 200 or 300 witnesses at that point in time, you're giving them in drips and drabs, and then as it gets closer, you have this very large outlay of witnesses, probably a third, more than almost 2/3 of what the number of the witness unit persists. So, I mean, that's where I think that they're kind of, they're chapped, and I'm perplexed about why it is that it just kind of keeps growing. And to that, I can't prepare because I don't know, I don't have a complete witness list information because then everybody here is going to interview these people before trial. They're going to go ahead and see if they can go ahead and talk to them prior to trial, professional lay witnesses. And it's a daunting task to begin with this many people. But to the extent that we have commenced trial on the 4th of January of this particular year, and then we have gone down this path until then, it would be one thing if you had witnesses, or maybe 10 or 11 or 12 or whatever else. I mean, but well, I could see that. I mean, but this is a lot, and I mean, and it affects their ability to prepare, and it affects the court's ability to kind of proceed seamlessly. So, and you know, I mean, I have various remedies, but I mean, usually indicates a continuance. But you know, I certainly have to look at the evidence that that was not timely disclosed, and I have to look at whether or not there's prejudice to the defendant in bad faith by the state. But the problem that the challenge court's going to have to begin with is we don't know what evidence that goes to, whether or not it may be exculpatory or not. So, you know, I may revisit this at some point, but I do need you to complete this list, and let's just. And I mean, I'm disappointed that as you all advocates, because I know that you all can do this, and I've watched all of you try cases, and this is something that you all know how to do this better. What I'd like you all to do, I'm going to finish up this up, is to not personally disparage one another. Please don't do that. Not for cheapness of anything else. Please, please, please do not disparage one another. You can fight hard and not make it personal to each other, but you are all moving into that particular space at this point in time, and that's not what I want to see. It cheapens you as advocates, Mr. Stewart and stuff. I'm going to tell you that right now. So please don't do that again. Don't come before me again and talk to the court like that. I'm not going to have it. That is not the spirit of professionalism. I know.
So he's chastising Steele.
Well tried and well fought, but there's nothing gained in attacking one another. You still got to get the job done. So, Ms. Love, Mr. Steele's concern is, and he says that you tendered these witnesses after the 8th of September, and he's asked me to fashion some remedies. So, what's your argument as to that?
That Your Honor has ordered that the state index the discovery, that Your Honor has ordered that the state provide.
I want a real index, madam. I want a real index, okay?
Yes.
I don't want anything that's not going to be purely plain and very obvious of what it goes to. Because at this point in time, there should be no tricks, no gimmicks, and no kind of surprises at this point in time. We're too far down the road for that. I mean, and I know that your colleagues across the way, they're angry, and they probably have every right to be. I mean, because that would not be something that you do to somebody else. I mean, even in another type of, in civil cases, you dump this kind of thing, the time period you did, I exclude all of it. I just would. And the law allows me to do that because and in that respect, I am trying to be fair to all parties, but that is a big question that I'm going to have to probably resolve. But I can tell you first, we are going to do a complete witness list and a complete index that's accurate. But I'm going to reserve the issue of whether or not it's prejudice to the defendant and whether or not law acting in that case. Because I won't know that until I have everything. And Mr. Steele, as much as you'd like me to exclude this, I think there are other constitutional problems if I do that. So I need to get a full universe of what we have to begin with before I make a decision. And you seem to indicate and tell me that the state may prohibited from introducing evidence that was not timely disclosed, only upon showing of both prejudice to the defendant and bad faith by the state. I don't know how you're prejudiced. I certainly will, depending upon what is produced to you, entertain additional motions as to whether or not you are able to properly prepare. So, and that's the other thing that I have concern about.
we're 9 months down the road. And as your colleagues have indicated, we're fairly close, within a month's time to kind of getting started. We got other business we got to take up, and we don't need to be not professionally ready as advocates. And I want to take care of as much as I can. I know that trials has a lot of uncertainty and unknown, and all of us can deal with that. That's what we get paid for, and that's what we do in our roles. That doesn't bother me. But what bothers me is when you've got this particular type of absence of disclosure, that I can foresee it causing delays and problems. And that's what I'm trying hard to prevent, because I don't want there to be any problems. You deserve a fair trial, and each one of these defendants deserves a fair trial. The only way they get a fair trial is if they get everything that the law entitles to them, and they get it timely so they can prepare. So, Mr. Steele, I'm going to take your remedies under advisement. But Ms. Love, you've got to, this thing needs to be done and complete by Monday. Both of them. The witness list, everything la-di-da-di that is missing at this point in time, it needs to be color coded. We need to go ahead and also provide a complete index. Because as I mentioned earlier, I've been a lawyer for 35 years. I've tried active cases when I was in the Army, and when I was doing what you're doing and doing what, representing individual clients. I can go trial that without knowing exactly what I needed, and from the perspective of what my adversary was going to need in order to prove. So it's not of any consequence that you all don't know how to prepare a case and don't know how to get ready. But I think you tie one of those hands, and this is why discovery disputes, in civil and criminal context, end up being very important, and people get very angry about it. Because it's like, I can't prepare and I can't kind of do my due diligence as a trial lawyer. And part of that is just being prepared in the sense of, I need to look at every single witness that you potentially may call or account for them, and I need to look at every scrap of paper, because if I don't, I'm not doing my job. That's a civil or criminal case. That's anybody that's worth their salt, anybody that's prolific at trial law will tell you they read everything, listen to everything, go and visit everything, interview everybody, because that's the only way you're going to be prepared for trial. So to the defendant's angst and irritation, that's where they are. That's not a good place to be in. And they're asking me for a pretty draconian remedy, but in order for me to even do that, I got to figure out what the universe of witnesses is. And I need you all to have that, so we can have a fair trial, just trial, lawful trial as all parties, and this trial can proceed in a rather linear fashion. I know there's probably going to be some delays in terms of, they're always in trial. Always trials, there's always something comes up that you can't control. I'm prepared for that. I know you all will probably be as well. But I really need you to step up now. You and your colleagues, you to step up, put all this aside, and look and I will tell you all, in the interest of just being professional advocates, you need to be willing to fight hard, but to never make it personal. Ever. Make it personal, people make bad decisions, bad choices, and bad things usually happen. You look at any of the reports of that our Supreme Court and other courts have to deal with. When people start looking at anything but their roles and responsibilities and make it personal, other things happen that I know that you wouldn't engage in, but they tend to. So I'm just going to tell you right now, please just kind of step it back a little bit and forgive one another, okay? You're going to have to do it. But
Ma'am, is there anything else you want to tell me other than you're going to comply with this in its entirety by Monday?
We are going to comply, Your Honor. We want to make certain that we do, and we are asking, other than what we have described for the court, is there any further guidance that the court wishes to lay on us so that we make certain that we provide the index that the court and that each of the defendants are anticipating?
Here's what I want you to do. I'm gonna take 15 minutes. Can we get a couple representatives from the defense? I'd like you to tell and be able to put on the record what you envision. I think that both of you need to kind of have a clear path of what you're going to provide and what you expect, and I will kind of look at that from there. But just do that to begin with, so that I know exactly what you're asking for. If you write it down for me, that would be appreciative. So from the defendants, because it sounds like you all are the body that is most affected by this. Tell me in terms of what's been provided so far in court 1 and court 2, what's missing, what do you need in terms of, and in terms of the discovery index, what do you envision being able to do? I have asked, is Aaron here? Aaron, can you talk with the lawyers here? As I recess, the issue we're having is the transfer of a lot of data. We're talking maybe about 4 terabytes of data. What is the fastest way to get that done? The issue is that one party has it and needs to transfer it to another party. How can that be done as expeditiously as possible? Is that something you can lend your professional expertise to?
Yeah.
Okay. All right. So I'm going to, Mr. Ms. Randolph, sir, can you just check with our jurors briefly for just a second, please, sir, and let me tell them that we will be with them shortly, probably within the next 30 minutes, okay? And are your witnesses still here?
Yeah, give me a call for it.
Yes, come on.
Okay, so I'm going to go on to the next one because he just left and didn't tell us that we were going break. So he just left us all sitting there. So we were recording this. So I'm going to stop this and go and get the next recording. Okay, let's stop this. Let's go to the next one. Hold on a second. We're going to go to this last one because Mr. still was upset. And he's going to give the judge a piece of his mind. Wait a minute. Go. Hold on.
Name more than 2 questions.
I just have a couple. You didn't observe any other objects beyond perhaps observing, you can't recall if you observed the bag. You didn't observe any other objects, so.
I did not know.
I don't have anything.
Mr. Harvey?
No, I'm trying to wait to still parking up.
Discovery now,
Okay, here we go.
why discovery examination, I will authorize that at that time, so we can run it for the purpose, okay?
You hear Miss Tasha in the background? Yeah, her and China was running their mouths. I tried to tell them shh that I was recording, but they wouldn't listen to me.
Well, I think you made.
I told them now that they could hear it.
He's called, and that's different issue. I produced the records for them, and you can take it from them, okay? All right, unless there's anything else, folks,
Here come Mr. Steele again, y'all.
Oh, Mr. Steele?
Oh, there you go.
To add to Mr. Weinstein, is that right? What else did you want to ask me to add? Your Honor, would you please, if you think that this is fair, would you please write down your Tuesday to-do list or, issues, I guess?
Oh, he's gonna yell at Mr. Steele now. Watch.
We sent an email this morning. When I say we, it was sent by the Honorable Douglas Weinstein at 11:14 a.m. It was actually sent also to the Honorable Mr. Kern. If he'd be good enough, we could get that into the record. If you don't mind, if you do mind, because it's never been replied to by the state. And I'd also like the court to please look into the following. Like the state to answer the court's question. You've never answered. You asked the question, and you say, "What question?" You asked the question: why is the defense getting more discovery now? Why are there 308 official witnesses now? This Love never answered the question. I'd like those answered on Tuesday, if not one. In addition to that, Your Honor, I'd like the record to show. I was told this by Mr. Weinstein, that the state has, when I said that there was nothing February 22nd, 2023 as a witness list, the state told Mr. Weinstein that I was correct. They were misspoken. I want the record to show we received nothing on that date. And I'd like you to inquire as to why the discovery was not already organized. Now you have some insight into why it was bad faith and I've been prejudiced. I've been going around and around with it. And then I'd like you to also sit down and Tuesday, if you don't mind, and I'd like to pick up. I do, Mr. Steele. I've made kind of rulings on this already. And let me just get to the point to begin with. I mean, I think that in your effort to show prejudice and whatnot, I have to figure out the universe of stuff to begin with. So you can let me do that first, and then re-envision, and then re-ask me those questions should they be necessary. I'll go ahead and do them at that point in time. But I can't make any determinations about anything until I find out the universe of records. And look, you all are starting to pick at each other. Just cut it out. And yes, you are, sir. No, I'm not. Your behavior this afternoon, I have never seen you act this way. And I just find it to be unacceptable. I do. Never call out your colleagues. I mean, that's just lawyer etiquette. Sir, don't do that. Your Honor, you should read the transcript because I did it. What I said was the statement by Miss Love, the statement by Miss Love, and the statement by Love. Okay, but let me finish, please. It is one thing, sir, to be mistaken, but I would think that your colleagues will give you as much grace as you give them. I give everybody grace. And I know you do. And I know you're really upset about this. I really know you. I know you are, but it's getting to the point right now where I need to kind of first determine the universe of things that you're in that are supposed to be produced to you. It's not that I may not ask those questions, but can you let me just get through that verse? Your Honor, you know I want you to get, but when you say something like, I don't know if there's bad faith and prejudice, you know in June of 2022, this was all you. But here's the thing. Muse is going to tell, if this thing is looked at, I have to determine whether or not bad faith and prejudice exist. But in order for me to do that, I need to have the universal stuff. I may come to that particular conclusion at some point in time, but I think that I need to make some predicate rulings before then. The predicate rulings would be, I need to find out what was given, what was not, or was not given to you. If it's given to you at such a time and a place and a manner, then I think that you're not able to deal with it, then I can probably make some rulings consistent with what I have in front of me. At this point, I'm concerned. At this point, I do have some questions, but I need to kind of figure out the universal stuff to begin with. Once I kind of clear about that, I may answer the rest of those questions. I don't know. And you certainly can reduce them to writing, and I certainly will deal with them. But I don't think yet I'm in a position to kind of answer those for you or ask or inquire, because I'd like to first figure out what they're supposed to give you and determine that to begin with. And then I can kind of drill down into, okay, well, this was given some 10 months later and it affects this. And that may lead me to believe or not that there's prejudice and bad faith. I mean, so I believe that I'm just not in a position right now to do it quite yet, okay?
Well, and I take issue with you saying that I called out telling them that I did not, I was stating facts.
You have, but Mr. Even if it's true, okay, it's true. Even if it's true,
It is true.
but I just asked you to reflect and rethink your position, okay?
I'm going to,
All right.
now if you rendered 8 people,
Say again, I'm sorry?
I now have to interview, if you'd like to say, I interviewed 308, I could try to speak with 308 people that I disagree.
Okay, but here's the thing. If we, say for example, you have 600 votes, okay? If you've only got 150 that are germane to the counts and the things that you have, then that may make a difference. I'm not saying you don't have to interview those people, and I'm not saying that you may not need a continuous or some other remedy that's to be fashioned. But I think it would be ill-advised of me at this point in time to just rule at this point. I have some real concerns about doing that right now. But as I said, when I get the full universe of stuff, then I can kind of make some decisions. I'm not doubting what you said this morning or last week, but just let this kind of play out a little bit longer.
You let the record reflect there's nothing on February 22.
I'm sorry, let the record reflect what, sir? I'm sorry.
There's nothing that the representation, this is going potentially up to an appellate court. They're going to make sure that you know this. That I waived issues, I didn't get rulings from the court. This record has to be good. There's nothing. That's what the state told Mr. Weinstein. On February 22nd, 2023, when you directly asked the state of Georgia, is Brian Steele right? They said no. They said there were filings on February 22nd, 2023, and March. They said,
Okay, well, like I said, reduce those things to writing.
I did.
And
And I asked Mr. Kearns if he could, with your permission, make part of the record, and now it's part of the record. And if I'm wrong, they need to correct it, because otherwise the appellate court is going to do exactly what you just said. Well, we don't know.
well, they don't know because I haven't made rulings to that effect.
I'd like you to ask me. That's why I've been asking. That's why I say on Tuesday, please ask these questions.
Reduce them to writing, and I'll consider asking them on Tuesday, okay?
Email to your court if you need another way.
Mr. Kearns, you have those, sir? Okay, all right. So I'll pull the email because I'm not party to that, and we'll ask those questions on Tuesday. All right?
I've never been treated like this before.
Mr. Steele, this is I know that you have stated that, and I know that you to be a professional advocate. I've seen you over the past 30 years, and I have no disagreement about that. But each case is different, and I have to make certain rulings based upon what I see.
I'm not saying that I'm not, I never tell lawyers I'm in. I just, but I think that the hardest thing lawyers have with jurors is, if I tell you that I need a referral ruling, and I need to tell you why, you disagree. Now, I didn't say I wasn't going to make a ruling, but I'm just not in a position to do it at this point in time. And that, I think that, I'll just say this, tell the call. Don't let your frustrations cause you to do something you don't like.
I have no apology, no regret, but I wanted to respond to what you said. It means, did you say means?
I know, but listen, I have let you all kind of treat you all as advocates and attorneys. And I know that there are a lot of things that go on with trials and ebb and flow and other things. And I'm going to continue to do that. But you all have got to work on communicating, and you've got to work on some other things as well. But given what you've raised, Mr. Seal, like I said, it's still an open matter for me to do. Okay? Okay. Okay. Anything further? All right. Are you bringing something from Anton? That's all I want to hear. Well, you were in contempt months ago on that. You still haven't satisfied it. Oh, I can think of several reasons. Your phones rang at least 3-4 times, because then that was before Mr. Adams peeped you. I mean, but
Yeah, I don't know what the universe, I'm just aware that this case, and all I was
it hasn't. Ms. Lover, Ms. Hilton, are you prepared to deal with that particular issue in terms of providing that? Because that would kind of expedite time. I believe you got a Sixth Amendment issue right to defense on that issue. And
The state is not. Access to documents.
Yeah, that's China and them laughing in the thing.
But it says that,
That's China and them laughing in the courtroom upstairs with me. That's why I need to be back in my media room instead of up there.
and requested, and that the senator, then give to the requesting party the right to keep those criminal records.
Thank you.
35 what?
Yeah, sure.
Well, it means public agencies, all levels of government, which perform as their principal function, activities related to apprehension, prosecution, adjudication, or rehabilitation.
No, it's not Black China.
Sir, go ahead.
I want to say shout out to Obnoxious. I met him at court today, y'all. Y'all know who Obnoxious is, right?
Hold on. 34 dash what?
Yeah, do y'all know who Obnoxious is?
Okay.
He was on The Apprentice.
Gotcha.
Donald Trump's Apprentice. He was on there. Judy. Hood One TV Gaming. Hello.
Why can't I do that? I mean, that's it.
You still don't know? Oh.
I understand who those folks are. I mean, that would be anybody who has a criminal justice or other function or the right to have a term. Just in the absence of the contrary, I'm going to order that you go ahead and do this. Okay? Or at least facilitate that, all right? I believe that pursuant to make criminal history records of dependent witnesses and criminal action available to counsel.
In order for a name to be certified, there are certain statutory requirements of and you are not to run some of the street private.
What about the court? If I order you to produce them, well, because I'm an adjudicating body under the statute, would that suffice?
I asked the court to allow me, the court to just make certain that we do not, in violation of our requirements under the laws and,
Okay, that's the end of it, y'all.
35-3.
That's the end of it, because after that, the what's the name? The mic was horrible. So, guys, that's the best way. That's the best I can do for you guys. Hey, Mr. Bush. That's the best I can do for you guys and trying to get that stuff over to you guys. So, yeah, anybody have any questions? Anybody have any questions in regards to that? Yeah, I needed that audio to because I wanted to make sure, because with channel 11 not showing up, it's been terrible for me. I have to go up to the room where everybody else is, and I'm telling everyone to shh. I'm recording, and then I have to have my phone inside of this little pouch. That's what you hear in that little rubbing thing. That's a pouch that my phone is inside of. I have to put the phone near a speaker because they won't let me have my phone out because I'm in a room with the family. So my normal room, which is the media room, there's nothing going on because the camera guy is not here. So I can't get any footage. I can't see anything. And the best thing I could do is just go upstairs where the family is in the other, in the overflow area. So I did the best that I could to bring you guys what I could, because I felt it's something that is needed. And I don't understand why channel 11 did not show up for This Is Motions. Even tomorrow is going to be no, tomorrow they're just going to do what's the names, and then the next week, hopefully whoever comes in next week, camera person, they'll be, because they're still going to be doing motions next week. So hopefully somebody comes and help us out and get some visual along, because I like it when Law and Crime highs it up, because you guys get a chance to see everything, and I don't have to give you that part of it, but give you inside stuff of what's happening inside the place. But I hope you guys got a chance to see it. I had to postpone my interview to tomorrow with Mr. Hill because I didn't get out of court until 7 o'clock, almost 7 o'clock. I got out of court today because they were still doing this. So tomorrow I go to court. Court starts at 3 o'clock, and it's only going to be the jury selection stuff. And then Friday, they're not going to be there too long. So I don't think I'm going to go Friday. They're not going to do any motions or anything like that. They're just doing jury selection. So next week is when they go back to motion. Hopefully somebody with a camera person will be here. All right. Be there, not here. So I hope you guys got a chance to enjoy it. And I'll see you guys tomorrow. All my R. Kelly supporters and friends and family and all that. I have some updates that I'm going to bring on this side later on. Am I going to do it tonight? I'm tired, but I think I'll let the thing read it instead of me reading. I don't know. We'll see. Let me know what you guys want. But anyway, good night, everybody. Have a good one. See you later, Thugger Daily. Hope you was able to get something out of it. I apologize that that's the best I could do. All right. Good night, everybody. Love you guys.